grabbing a vent.
Sorry, go ahead, continue.
No
We're
worries.
recording. We're recording your fabulous introduction.
Well, yeah, I guess I should finish introducing myself. So I work exclusively in the cannabis space, and I like to say that I am just the person cheering my clients on and helping to keep them compliant and licensed, and just doing all the things that they need me to do to help keep them moving forward. And I feel really lucky and grateful to be able to do this. And it is certainly in my very long decades as a lawyer, 23 years as a lawyer, this is certainly the best form of it that I have ever had. And so I feel super lucky to be able to do it. So Schedule 3 is certainly a headline grabber, and we're going to talk to you today about what we think it means. I think one of the smartest comments I've seen so far on Instagram was today, and I think the person who said it is on here, but just pointing out that nobody knows how this is going to shake out. It doesn't matter if you have a law degree, if you are a CPA, if you've been in the legacy market, if you are a legislator. As we sit here today, that's my big disclaimer. Anybody who tells you they know how this is going to go has no idea how this is going to go. Anyway, that's my intro. So I will let Christine kick it off from here. And I really appreciate you all being online with us tonight.
Perfect intro. I couldn't agree more. So again, thank you all for being here. My name is Christine Gervais. I am a licensed CPA. I've been practicing for about 15 years now. I love to tell people that we accidentally found our way into cannabis in about 2019. Our first client was actually a roofing company, and he started a home grow and said, I need you to do the books for this. And thus the cannabis practice was born. And 5 years later, we exclusively serve the cannabis industry, providing all things accounting, tax strategy. I consider myself a nationally recognized expert on 280E. I have spoken across many different states about how 280E affects cannabis business owners. And certainly that is going to be sort of a linchpin of this rescheduling process. And I do want to just reiterate Jill's disclaimer there that she and I are providing our professional 2 cents, if you will, tonight. We are both extremely passionate about small business owners, especially our small business owners here in Maine, and we really want to help provide as much guidance as we can. But it is really important to understand that absolutely nobody has a crystal ball. And I think one of the things that led me to wanting to have this webinar tonight was the immense amount of misinformation that we already see floating around on the internet. And I think it's really, really important to get some clarity around, what is speculation right now? Most of it is speculation right now, but professionally, how can you prepare yourself as best as possible for what's to come? So I am going to, while we're chatting, I'm just going to put the Venmo code back up here again. If you just popped on, we are hosting this tonight to benefit MMCM, and we would sincerely appreciate any amount that you are willing to donate and support the organization. So with that, Jill, I'm going to actually turn it back to you. Do you want to kind of start and give us the lay of the land? Like what are some of the most burning questions that you're seeing coming from your clients around rescheduling and what it means, and what's happening next?
So just a little background that I think probably most of the people on here are focused in the medical program. Maybe some of you are in medical and AU. I want to sort of put AU to the side for a minute and let medical be the star, because that really is what this is all about. So as you certainly know, cannabis is a Schedule I drug. That means no accepted medical use, currently in a category with things like cocaine. So that has been obviously an ongoing issue. It is why you don't get those 280E deductions. It's why you don't have access to traditional banking and lending and mortgages and all of those things. The reason that the state siloed medical programs are allowed to exist. Well, it's a variety of reasons, but at the federal level, it's based on an appropriations rider that's referred to as the Rohrabacher-Farr Amendment. And what that rider has done is it prevents the Department of Justice, DOJ, from spending money to prosecute state legal medical cannabis programs. So that that is what has allowed medical cannabis to flourish. And I know I said I wasn't going to talk about AU, but I might as well throw out that what rolled out the red carpet or the green carpet for AU was the Cole memo, which was literally that. It was a guidance document in Department of Treasury, and I also believe I may get this wrong, from DOJ. So it existed in both of those, that basically set forth 8 priorities or guiding principles of these state legal regulated adult use cannabis markets. And that happened during the Obama administration. Colorado's the first legal sale of cannabis and an adult use program in Colorado was in 2014. And now here we are 10 years later, just now talking about a rescheduling. Side note, the Cole memo was rescinded in 2018 by the Trump administration and has not been replaced. But those Cole priorities still remain in place. You'll see them pop up in your lease riders, which is a personal pet peeve of mine right now. And I like to do like a heavy edit on Cole memo lease riders. But anyway, so then we got the news a week or two ago, and it's been rattling around all year, that there would be guidance and a rescheduling to Schedule 3. I think it was DHS that came out, DHHS, that Health and Human Services, that first came out with a recommendation to reschedule to Schedule 3, and then the DEA said, oh, wait a minute, you don't have the authority to do that. And so that really has to come from the DEA. Again, just a reminder that this is all occurring within the executive branch of our government. So that's where the president is. Why is that significant? Because this is an election year, and I'm not going to get too political, but other than to say, nobody panders like Joe Biden panders. So this is certainly a play for the youth vote. If it was really a play for the youth vote, this would be a descheduling. You very quickly, not very quickly, but within a week, saw Congress step up again. Chuck Schumer moving a bill forward to deschedule and to give access to banking to the cannabis industry. A version of that bill has been presented and failed probably 10 times so far in Congress. And just my personal opinion, the regulation or deregulation, scheduling or descheduling of cannabis is the work of Congress. That is the people's house. I continue to be disappointed at the decade that this has been batted around as a political football, when there are very few things that Americans agree on. But the legalization and descheduling of cannabis, I believe for medical cannabis, we have about a 90% consensus rate amongst Americans that medical cannabis should be legal and available. And I want to say the number is around 70%. There are very few things that we all agree on, but this is one of them. Congress has not enacted the will of the people is very frustrating. But now that they see their power getting taken away a little bit by the executive branch, the pendulum will swing. And those are the checks and balances of our federal government. A rescheduling to Schedule 3 is the federal government's acknowledgement that there is an acceptable medical use for cannabis. So it took them a while to get to know what you all have known for a very, very long time, that cannabis cures and that cannabis provides relief to a lot of people suffering in a variety of ways. So then the question becomes, what happens next? Christine, how far do you want me to go down this path? Well, I guess I'll talk a little bit about procedure of what we can expect. And then I think we can sort of get into the nuts and bolts of what this means.
That would be great.
So the change has not happened yet. So there has been no official rescheduling yet. Once
Can I
that
just get you to say that one more time? Because that is one of the biggest pieces of misinformation that I see out. People are like throwing parties and all these things. And so, just to clarify, the announcement was made on the 30th last week that the DEA agreed with the Health and Human Services Department recommendation that it should be rescheduled, but that gives us zero effective date, correct?
Correct. I mean,
Thank
I
you.
think everyone expects it to happen over the summer, like you'll hear me referring to. It's an election year, and if they're going to get any traction off it, it's going to happen soon. Um, but nothing will change immediately. This is going to be a really long process. And for those of you, and I'm sure there are many of you who are involved in the legislative process in Augusta, a lot of this will look like that, but at a federal level. So, once this change happens, there are a number of federal agencies that will then have to write regs for around this and rules. And all of those rules are subject to public comment. And I know this now starts to sound familiar, right? So the rules I mean, I'm sure there's rulemaking going on behind the scenes. I'm sure that a lot of that is already taking place. But the agencies that are impacted, and this is just to name a few, I mean, the IRS, the Department of Agriculture, the EPA, the DEA, the FDA, and those were just like the first five I could think of off the top of my head, of federal agencies that are impacted by a change to Schedule 3. So the rules will have to be drafted for these variety of agents. Oh, and yeah, I already mentioned the IRS. And then they will be subject to public comment. Eventually, rules will go into place. I'll leave it to Christine to give her opinion on whether or not 280E, any relief will be retro for 2024. My guess is no. So once those changes happen at the federal level, depending on what they look like, the states will then have to come in line. A rescheduling to Schedule 3 does not bring state siloed medical programs in line with federal law. So at that point, where we have had a hands-off approach by the feds will have hands-on. And that's where I think we can, during this webinar, talk about what some of that might look like. So all this to say is this is going to be a lengthy process. Anyone planning to throw parties about this, I think by the time it's all said and done, you will be holding a wake instead of a party. I don't know that this, in my opinion, this is not much to celebrate. And listen, I'm not going to downplay it. It's not nothing, right? Like, it's huge. It's huge to have the federal government potentially say there's an acceptable medical use for cannabis, and to potentially open up the doors to research that may be helpful, or not. So those are some of the things that I think are the positives that will come out of it. But people will still be going to prison over cannabis. People will still not have access. There's still going to be issues here. So anyway, lengthy process. In the interim, Rohrabacher FAR is still in place. The state legal medical programs are protected in the interim. So nothing will change right away. I think, and I expect the feds and all the related agencies will look to what happened with the Farm Bill in 2018, also known as the Agricultural Improvement Act of 2018, also known as the gateway to what is now probably $1 billion hemp-derived industry that I like to call, prohibition weed, because it really does flourish in states that don't have legal regulated adult use markets. So these were all unintended consequences of the 2018 Farm Bill. They're not going to make, or they're going to try not to make that mistake again. So I think there will be a lot more scrutiny on what this actually means. I don't think that the feds could ever have conceived of what flowed from the legalization of hemp, and they just could never have imagined it. And I always like to say cannabis so crafty, like all credit to all of you. for making the most out of what has been offered through the Farm Bill, which, side note, and I don't know how this will impact anything, if at all, the Farm Bill's up for reauthorization. It will not be reauthorized on time. On time would be now, and it's not ready to go. So I think for those of you engaged in the hemp derived market, we're going to see some changes there as well. All right, so I think that's probably a good foundation with my unrequested commentary mixed in. So
That was a that was a great foundation. Thank
I'll
you
kick
so
it
much.
to you, Christine.
Have always so appreciated having these discussions with you, and you and I are definitely on the same page that from my perspective, if I purely just focus on the tax and accounting perspective for our clients, a reschedule to Schedule 3 automatically makes 280E no longer applicable to cannabis, which is obviously a huge deal from a tax perspective for our clients. But other than that, that's about the only win that I see here. So you and I share that opinion that really, to me, descheduling was the only option that was the right option for these businesses. This, I think, just kind of opens Pandora's box in terms of new regulation in an already overregulated market. So let me ask you some of my immediate questions, and I can certainly provide my 2 cents on the tax side of things as well. But a lot of questions that we're getting are things like, will patients now need a prescription from a doctor, and what happens to the adult use markets if it's now considered Schedule 3, and does this automatically mean that we will see banking and payment processing those are kind of the more common ones. I don't know if you have thoughts on any or all of those.
I do. All of the other drugs in Schedule 3 require a prescription. So it's things like steroids and NSAIDs at a certain level. And so those require a prescription. If you follow that logic, then yes, medical cannabis will require a prescription. So what does that mean if you're a medical caregiver or a prescriber, or I guess a doctor or nurse or somebody who writes med cards? Potentially you would have to obtain a DEA number and register with the DEA, just like your doctor. So, and everything that is medical would be subject to FDA approval. And I think that's where the logjam begins. So yes, I do think that for medical cannabis, which does already require a prescription, it will require a prescription, but it will require a prescription written by somebody with a DEA number.
Ooh, that's like a bleak that's a bleak forecast to think about in terms of how this may potentially impact small businesses. And again, I just want to, if you kind of jumped on a little bit late, Jill and I both kind of gave a disclaimer that this is really just our professional opinion, both having served the industry for a while. And you said, Jill, like if you follow the logic, and that's really the best that we're able to professionally do right now, is historically look back at where are there other places in history from a legislative perspective, from a rulemaking perspective, that we've seen these things happen, and that's the best that we're able to use as sort of the litmus test to kind of predict here what might be to come. What about the banking issues? Because this is another piece that I keep seeing all over the internet, is that banking is going to just immediately be so much more available. We're going to have lending available. We're going to have payment processing available. And I have my opinion on that, but I'm interested to hear yours.
So let me say one more thing about the medical providers that will then lead into an answer to that banking question. Because one of your other questions is, will big pharma and doctors get on board? They're already getting on board with as a client pointed out to me, I think they had read an article about it, and I saw it, just how many patents are being filed daily on cannabis related products. I think the medical cannabis, that we're talking about, that'll undergo FDA scrutiny, and require prescription is going to look a lot more like medicine, a lot more like pills, and a lot more like a Pedialyte, I believe, is the drug for epilepsy. I think that's really, where big pharma is headed. I honestly don't know what's going to happen to medical caregivers who are providing cannabis that you all have grown and processed, and you're doing that to patients who are providing it to patients who have received a med card. I have no idea how that's going to change because it's just not reasonable to think that medical caregivers are going to go through that process to get a DEA number to be able to dispense these products. So that leads into banking. So the folks that are going to have access to banking are these big med cannabis companies. I would think that for companies that are conducting these research or developing drugs or, creating these items that are patented and the equipment to make these things, like all of those companies, sure, they're going to have access to banking and lending. Is it going to change anything for caregivers operating in state legal markets that have not yet been aligned with federal law? Probably not right away. I think, in Maine, we're lucky because you all do have a few options now for banking. So I know it's a pressing issue on the lending side and on the personal side for a lot of you who can't get mortgages or who get a credit card shut down or a bank account shut down. I don't see a big change coming right away on the banking side for small business.
I don't either. And that's why I'm, curious, and I'm kind of asking what other professional opinions are, because I agree that this is still a controlled substance. It's just on a different schedule. And so not being in compliance with federal rules, as you just said, we don't know what those federal rules are going to be, but failure to comply with those federal rules is going to impact your ability to have access to banking, lending, payment processing. And so I agree. I don't think it's going to immediately just open up this floodgate of new banking opportunities. Like, you're not going to be able to go down to Kennebunk Savings Bank, sorry, Kennebunk, and just, get a mortgage with your W-2 from the dispensary. I don't think. We did get one question, and I'm actually curious what your thoughts are on this, Joe. Christy asked, any thoughts on the Cannabis Admin Opportunity Act? I know that was just recently introduced, and it proposes removing cannabis altogether from the Controlled Substances Act. Just for those of you who don't necessarily know what it is, I don't know what your 2 cents is on that, Joe, but considering we can't get Safe Banking Act through Congress, it seems unlikely that one is going to go through.
I have always fully expected medical to go, through the FDA process and to be regulated by the DEA. And I did always expect adult use cannabis to go to the ATF. And so, when I read, and I haven't really looked into this, I Googled it when I saw the question that the Cannabis Administration and Opportunity Act would shift oversight of cannabis from the DEA to alcohol, tobacco, tax, and trade. Yeah, I'm all for that. I don't see medical going that way though.
Yeah.
I think there's going to be a divide, a bigger divide at some point. Adult use is getting no protection from this change. And I want to, because I know now that I've looked at the participant list, I know many of you are also operating in AU. This is not a change for adult use at all. So this is really I just always hope that the state programs stay intact for as long as possible. One of the other questions that is on here coming up that sort of dovetails on this is whether insurance companies will cover it. I think insurance companies probably are already covering some of this. In states with the more restrictive medical programs, I'm from Georgia. The medical program in Georgia is probably one of the worst in the nation. It's now a low THC oil program. My guess is that's probably covered by insurance. I do think the drugs that go through the FDA approval process and things like that will be ultimately covered by insurance. Will cannabis obtained from a main caregiver or main medical dispensary be covered? Probably not anytime soon. And then will product be able to cross state lines? I know is another one that's coming up. Maybe. A lot of people do think that this sort of will usher in more interstate commerce again on the medical side of things. That only makes sense, right? So if they're going to start producing cannabis-based prescription drugs that will fall on in Schedule 3, you can expect that those drugs will move across state lines. Will it open up interstate commerce for adult use? No. And will it open up interstate commerce for a caregiver? No, not in my opinion. No big change there at all.
I really want to hear what your thoughts are. And again, this is all speculative because, of course, again, we don't have our crystal ball. We don't know what's coming, but there has been a lot of, we'll say, rumors, if you will, coming out of Washington around the federal excise tax discussion. And I'm curious to hear what you think might happen with that, Jill. Are we expecting to see some type of a federal excise tax as a part of this? What's your thoughts on that?
To be honest, I don't know enough about it. I don't know. Again, I would see that more on the adult use side of things, tracking tobacco and alcohol. We have at least one alcohol expert on this call who maybe can give us some insight into that. But I don't know about that on the medical side. I don't think so. Interstate commerce. Sorry, I was looking at the couple of questions that have popped up. I know that, so a question popped up, wasn't a bill passed in Maine about to position us for interstate commerce. I know that was on a discussion topic. I'm not so sure that passed, but there has been a lot of talk about preparing Maine for interstate commerce, but I don't believe that passed. But I know there's folks on here that can chime in and let us know. And is the Safe Banking Act still a thing? Yes, I slightly touched on that in the beginning.
11 time is a charm.
Sure. Lucky number 11. I mean, yeah, the Safe Banking Act, I think, is probably a lot like what Chuck Schumer just introduced. So the Safe Banking Act, it's died, 1,000 times already. And so Chuck Schumer just put forth another version. I don't think anybody expects it to pass based on the composition of Congress. So it's likely to fail again. But who knows? I mean, I fully believe in the checks and balances that exist in our government. And like I've said on Instagram and on here already a couple of times, when Congress senses that they've lost control over a situation, I mean, that's why you saw Chuck Schumer come out so quickly and say, "Oh, we've got this, Congress is gonna deal with this like we should have done a decade ago." So no, safe banking, that there is a version moving now, but nobody expects it to pass.
So what types of tax questions are you getting from your clients around what this means?
I think, the big ticket item, of course, is 280E, which impacts retailers far more than any other segment of our industry. And it would be just such a game changer in every way. So everyone's asking about excise tax or 280E. They're also asking about Maine excise tax. That's why that was in the back of my mind.
Yes, yes. Everyone asked me about the main excise tax as well, which, if you're at all subject to it, it's certainly a cash flow hindrance right now. As far as 280E goes, so 280E, the way the tax code is written, specifically only applies to drugs that are on Schedule 1 and Schedule 2. So a move from Schedule 1 to Schedule 3 would mean that 280E no longer applies to cannabis. Which is great from a tax perspective because the tax liability on this industry has been astronomically awful, for lack of a better word. It has been a huge hindrance to cash flow to pretty much every business in this industry. It's certainly something that we've advocated to have addressed, removed. Most of the states that have state legal markets, like Maine, for example, have elected to decouple from 280E. So what that means is that the state of Maine does not recognize the application of 280E on state returns. So if you are a cannabis business in the state of Maine, you're basically filing a federal return that looks one way, that has 280E applied appropriately to it, and you are filing a different return with the state of Maine. We call it a pro forma return that files it as if you were any other business that takes your normal operating deductions. So the operating deductions is the biggest change there, that 280E disallows any type of operating deductions if you are trafficking in a federally controlled substance that is on Schedule 1 or Schedule 2. So this reschedule would completely remove that and would create a pretty significant windfall in terms of future tax liabilities. And I really emphasize that future because I think there's some common misconception around who gets to make the decisions of the effective date of this change. So if they come out, let's say it's this summer, Jill, and they come out on July 15th and say it's effectively moved to Schedule 3 as of today. As of July 15th, 280E would no longer apply to these cannabis businesses. But what do you do with the first half of the year or all of these prior years where it was applicable and you had these astronomical tax liabilities? I do not think that there is any type of priority being placed on retroactive changes to the application of 280E. Again, just my professional opinion, but of all of the rulemaking that I think is going to happen over the next couple of months in order for this to become effective, I do not think that there is going to be any type of significant priority placed on retroactively changing the tax laws and retroactively applying any type of 280E relief. I would love to think that I'm going to be wrong, but I can tell you from a professional standpoint, we are tax planning with our clients right now as if 280E will be effective through the end of the year.
Christine, can you address some of the headlines that you and I have talked about this, about some of the MSOs filing amended returns and getting huge refunds?
Yeah, absolutely. And if anybody wants to, I'll pop our web address in here really quick. I wrote 2 articles on this recently from 2 kind of varying perspectives on some of this. So if you go out to our website and go out to our blog, there are 2 pieces that I did kind of in a little bit more detail because I won't have a ton of time to get into the detail with them right now. But couple of things happened over the last 6 months or so. The headlines came out last year that Trulieve filed for about $143 million worth of refunds from the IRS, so federal refunds. Terra Ascend was the other one who filed for, I want to say it was closer to the ballpark of about 27 million in refunds, significant refunds. Trulieve announced that they received their refund. I don't believe it was the whole 143 million because that was across a couple of different tax years, but they did receive a significant portion of it, which raised a lot of eyebrows, especially from the accounting perspective, because none of us in the accounting profession expected them to get their refunds. That was kind of a shock. And how fast it happened was a little bit of a shock too. So again, my professional 2 cents, nobody really knows. What would have happened if the IRS told Trulieve, no, we're not going to give you your 143 million back? The expectation was that Trulieve would have obviously opened up court proceedings to address their request for a refund in court. If that had happened, a lot of Trulieve's tax positions, like the position that they had taken that led them to requesting the refund in the first place, would have likely been made publicly available information. My personal and professional opinion is that the IRS strategically did not want the rest of the public to have access to what Trulieve's strategic position was that led them to ask for these refunds, and that it was less expensive for them to just cut a check and not have that publicly be available to anyone else. TerraSend, I believe, has received some of their refunds as well. And then we can dive into the nitty gritty of like, well, what do I speculate that either one of these businesses did or didn't do in order to request the refunds in the first place? And that is a really deep rabbit hole to go down. It could have been that they got really bad tax advice for several years, that they weren't being aggressive enough on their returns. I think it's TerraSend who specifically said that they are operating now under the assumption that 280E never should have been applied to state legal businesses, but that has not been addressed in court. So that is their opinion. And what I'm going to caveat all of this with, which is a little technical, but it's important for people to hear, is that both of these organizations have taken what we refer to as an uncertain tax position, meaning they have decided they're taking a specific position on their tax return that they don't believe something should or shouldn't be applied a certain way. And if you take an uncertain tax position on your tax return, you are required to disclose it to the IRS. So if you decide that that's something that you want to do for your business, you are welcome to. That's the way that the tax law works. But you essentially have to tell them, hey, we took this specific position on our return. For instance, we decided that 280E no longer applied to us. We're not 100% sure that you're going to agree with that position, which is why we refer to it as an uncertain tax position. And we now have to disclose it to you. There is no faster roadmap for the IRS to audit you than to put an uncertain tax position like that on your tax return. There just isn't. And I don't want to speak on behalf of anyone on the call or even not on the call, but most of our clients are just not willing to be the guinea pig that raises the red flag and says, here, IRS, here is my uncertain tax position. Please come in and go through all of my documents and records and prove me wrong. These bigger MSOs have much deeper pockets and much greater resources to be able to go to battle for what we would expect to be a years-long court disagreement in tax court to address these. And so that's kind of the shortest possible version that I can give you as to, what I think happened in some of those cases.
So you are not sitting on a pile of amended returns here.
I am not. I mean, and I will be totally candid that we had some very, very frank conversations with a lot of our clients about whether or not they wanted to amend their returns, whether or not they were willing to take some of these uncertain tax positions. And for us professionally, that is a client by client conversation. Everybody's different. Everybody's risk tolerance is different. Everyone's resources to go up against the IRS in tax court is different. Eventually, somebody's going to have to, really. Somebody's going to have to. If we're going to see any type of retroactive change, it's either going to have to be, in my opinion, it's going to have to be something that's done congressionally. Like Congress is actually going to have to make the move and make the decision that they're going to retroactively make a change to 280E, or it's going to have to be something that comes up in court and we're going to see some type of legal precedent come from there. But absent one of those two things happening, I do not believe that you're going to see any type of retroactive changes. And I do not think that most small businesses have the resources to start taking on these battles, unfortunately.
Awesome. Thank you. Um, we can just let Trulieve take the hit and litigate it for the rest of
Yeah,
us.
well, so I think that's what most people were hoping for. And it just didn't happen. And again, I'm speculating. Nobody really knows why the IRS cut the check, but professional speculation is that it was just a lot less expensive um, to not allow a situation where those tax strategies would have been made publicly available. And I don't think that the IRS was prepared at that particular juncture to take on that potential for legal precedent being set.
One of the other questions that you had on our list that we wanted to hit tonight is what kind of compliance changes should small businesses and caregivers expect to see? I wish we had a great answer for that. I think depending on who you ask, the first thing that comes up is track and trace. And I hate to even say that out loud because I know heads are spinning. And certainly I'm not advocating for it. But when you talk about the feds getting involved in increased regulation on these medical programs, certainly track and trace becomes part of the conversation. But we really won't know about compliance changes. I mean, I think one of the things that like I referenced is the FDA approval process and what flows from that. So I wish I had practical advice for everybody on what I think they can expect, but we just don't know. I think there's going to be such a divide in what it really means for what medical cannabis on Schedule 3 really means. Like I've referenced, the epilepsy drugs and the low THC oil that's in use for seizure disorders. And then there's, Maine's robust medical market with everything that's available. So I think we're talking about just a huge divide between what medical looks like. So I'm not sure how compliance is going to change at the caregiver level. This association and all of its members have done such a great job at keeping regulation as reasonable as possible. And I expect all of us will continue fighting that fight in the years to come.
I'm going to take that perfect segue to just one more time. We have about 10 minutes left, so Jill and I will keep taking questions. But again, if you hopped on a little bit late, we are asking you to please scan the QR code and make a donation, no matter how big, how small. We appreciate all the support to MMCM. This organization has been doing advocacy work on behalf of Maine's medical caregivers for a long time, well over a decade. And I'm sure as most of you have gathered here tonight, we are going to have a lot of advocacy work that's going to have to be done as we see this rulemaking process start to unfold in order to protect the business owners and protect the caregivers that are in the state. And so if you are able to donate to them and support that advocacy work, we very much appreciate it. I also wanted to ask the question about whether or not you have any thoughts over who would have final say when there's conflicting rules. So, I mean, my guess is that as part of this rulemaking process, we're going to see some federal compliance come out of this that is in direct conflict with some or all of the state rules. And I don't know what the thoughts are in terms of um, like what happens in those cases.
Well, we're living in it. I mean, that's what we live in every day. So we are currently in conflict with federal law. So when, that's the simplest way to put it, is
So true.
we have been, we continue to be. And so who has the final say? Well, right now the states do, don't they? Because we have all of these state legal medical programs and state legal adult use programs. But again, remember, the foundation of this the roots of these thriving markets come from federal action, the Cole memo, Rohrabacher Farr, so it's not like the feds are just like, oh, they've put a stamp of approval on it in a kind of passive way, or as much as possible, or left the door open to allow these markets to grow, and it wouldn't have happened otherwise. So, at its most basic level, the feds may have the final word on a lot of this. There's at least one lawyer on this call way smarter than me, and I invite her to chime in if she has an opinion on this. But this is the world we live in right now. We are in conflict with federal law every day. So it's hard to say in the end how that will all shake out. I do think that once the feds, once they've moved it on the schedule or potentially descheduled if Congress acts, that is going to give the feds more authority. At that point, they will want to regulate. They will no longer, stand aside. And they will regulate these programs. So, oh, okay. I was just reading another message. So yeah, I expect to wear a tinfoil hat. I'm a realist. So I do think in the end, the feds will regulate these markets. And I think that that's what opens, yes, that was a shout out to you, Christine Bailey.
Yes, it was. We see you. We both see you.
Yes, we see you out there. So Christine Bailey is on the call, and I'm sure she won't mind me shouting her out. She was general counsel to the Massachusetts Cannabis Commission. She's now also licensed in Maine and in Connecticut, and really looking to do cannabis work here in Maine, and she's brilliant. And so she wrote an article about this very topic that I referenced in preparing for tonight. And so she's out there lurking. And so I definitely welcome any comments that she may have to put out there in the chat box or in
I
I
basically have been picking up my son and caught what you said at the tail end. Did you have a specific question?
The last question, Christine, the other Christine put forth was, in the end, who will have the final say, the feds or the states?
Well, it's always going to be the feds, right? Because of preemption principles. So what the states will have to follow. Now, if the feds do not regulate in a particular area, the states can fill in the space or regulate in that area. So I think in general, we just have to wait and see what the feds are going to do. I have said in that article in other contexts that the expertise is really in the states and in the industry. And I think it'd be incredibly misguided of the federal regulators not to acknowledge that and take advantage of that. And they did, I think, to a significant degree, take that approach with hemp. In other words, they did reach out to the states and get a sense of how the states were approaching hemp. And they asked the states to submit plans, and then they used those plans to develop standards. Now, hemp is very different from marijuana. So I'm not sure if they're going to do exactly that approach, but I think there's some appreciation that there's a lot of expertise at the state level, both in the industry and among regulators, that they just don't have in-house at this point. So I'm hopeful that there were some comments by the head of the FDA, I guess about a month ago, that suggested to me that, you know, he understands the importance of medical use marijuana to patients and caregivers and to those involved in the industry. There seemed to be a level of respect there or acknowledgement. So I'm hoping that spirit still continues. So, but at the end of the day, we really have to kind of see where the feds want to regulate in this space and figure it out. I think one of the most important things this community can do is to continue to advocate for mechanisms for just maintaining the status quo so there's not a huge disruption in patient supply. And that can be done through things like the budget rider that you mentioned at the earlier end of your talk. So anyway, I don't want to hijack your talk because you both of you doing an excellent job. I will turn my camera off and mic off. So I hope.
Thanks so much for jumping in.
Before you go, yes, thank you so much. If anyone does want to read the piece that you wrote, can I pop your contact information into the chat and have them reach out to you?
Yeah, absolutely.
Perfect. Excellent. I'm going to do that right now. We have about
Dated at this point, but I'm happy to share it.
everything's outdated the next day after we write it. I think I wrote something on True Leave, and then a couple months later they got their refund, and then I had to rewrite. So it's okay. I'm gonna pop Christine's contact information into the chat in case anyone wants to reach out to her. We have about 3 minutes left. So if there's any other burning questions that we haven't answered, I know that some of the answers aren't exactly answers. They're, just like we said, the best possible answers that we can give right now. But if anyone has anything that we didn't address that you want to ask, Jill, thank you so much for being on tonight.
Christine, thank you for organizing it.
Yeah, of course. My pleasure. And just please, again, one more time, just take a minute and make sure that you're supporting MMCM. We certainly would not have a lot of the more positive legislation that we do here in Maine if it wasn't for the work that this organization does. And so we want to make sure that we're continuing to support them in the efforts that we're certainly going to need to have in play over the next couple of months. So. Awesome. There's no more burning questions, so we must have done a good, we must have got it, or we've horrified everyone. I'm not really sure which, probably a little bit of both. Again, if any of you have any other questions that you want to ask either Jill, myself, or Christine Bailey, our contact information is all in the chat. I put all of our email addresses. Jill and mine are up at the top, and I just popped Christine Bailey's in. Please feel free to reach out to us. You can also reach out to MMCM. They know how to get a hold of all three of us as well. So they will be happy to get you our contact information. And I believe all three of us will be at the trade show in August talking about some of these things. Hopefully by then we will have some more answers or some more direction, but you never know. So I also did record, so if anyone wants the recording, please reach out to me. I'm happy to send it to you, and we'll try to get that out to everyone as soon as possible.
Thanks so much, everybody. This was great.
Yes, thank you all for being here. Appreciate it. Have a great night.